I welcome everyone. Welcome to our traditional forum of the participants of AIFC. My name is Aslan Kokayev. I'm heading the division on the development of business company Hypo, and probably I will speak about our department, what we deal with in the framework of Business Connect. We help our participants in the business and the companies that come to our jurisdiction from a moment of registration to the moment of getting the licensing to the following support. We help our participants to make their work more comfortable. And currently, our jurisdiction has more than 850 companies that are registered. We are developing very fast. If before in our forums we consider how to become the participants of the forum, we considered the preferences and advantages for our participants. It's not the issue anymore. We have enough participants. I think that there are many questions connected with those that have already registered in our center. And today we have two main topics that we want to discuss. So what happens with you when you became the participant of AFC and different moments connected with post-registration period. And the second part is employment regulation, because we have the representatives of consulting companies that will help us to consider this issue. We will speak how in our jurisdiction we work on the selection of personnel from the point of view of regulation of relations. We have my colleagues with us, the representatives of the participants of AIFC. I would like to give the floor to my colleague. She is the head of the division of post-registration, Assem. Akhanova, please, the floor is yours. Hello.
Hi all, thank you for joining our session. I'm representing post-registration unit under participant support and sales department. And today I'm gonna speak mainly about what happens to companies after registration, touch base of so-called obligations of our participants, and enlighten you on processes and functions of our unit. So indeed, once you form a legal entity, it doesn't necessarily mean that you're ready to commerce your business. And there are actually certain acts beyond of incorporation that you need to acknowledge and consider before you can start operating your business. So let's dive into post-registration stage. Mainly to sum up, it's all about the ongoing staying in good standing with statutory and regulatory requirements in order to maintain the legal status of an AFC participant. And there is a couple of things that you need to consider. That's such notify of change of any registered, in change of registered details, submit annual reporting, and of course, conduct your business in compliance with local and AFC laws and regulations. And also, while setting up an office with associates, you need to ensure that you have adequate staffing and that you are contracting with your employees in accordance with AFC employment regulations. So moving further. Here, this slide contains basically all procedures that our unit handles and supports on a daily basis. But trust me, in a month, you will see more procedures added to the list. The list will be slightly changed as per the organizational legal form of the company. For example, if you are a partnership, cannot change directorship. So such procedure will be disapplicable to partnerships if they don't have directors. Instead, they have designated members who perform executive functions. So before applying for change of register details, it's highly recommended to get acquainted with the applicable rules and regulations. Also, as you can see here, all post-registration procedures, like particularly all, are submitted together with a fee. There is associated fee, 50 USD, and it's non-refundable. But there are some procedures that are still free of charge, such as suspension of activities, submitting the waiver or modifications, license withdrawal, and so on. Here, I'll just talk briefly about the process of change of register details, how it goes. So for here, for a licensed participant who undergone the authorization process and got a license, needs to contact its relationship manager in first place, relationship manager at supervision division. So depending on the type of license, you need to contact the supervision. For example, if you're having like banking, insurance business, then you need to contact the prudential division. So here you will submit, you need to fulfill certain forms, then submit it to your case manager. Afterwards, the unit will undertake the assessment. Maybe it will require additional information or provide some comments or undertake some interviews of approved individuals in case you are changing the person. So, and here as a company, you need to perform proactively, incorporate all comments as soon as possible. Provided that all conditions are met, here approval letter will be issued. Afterwards, you can proceed further and apply to Office of the Registrar, where you also need to complete some bunch of forms. The process will be particularly the same. Instead, Office of the Registrar doesn't check the competency and expertise of the individual, as, for example, it happens at supervision stage. So here, once all forms are, the application package is materially checked and full, and all conditions met, order will be issued by Registrar of Companies, and then the forms will be submitted to Minister of Justice, which in return will assess it as well. And in case of absence of any comments, Minister of Justice will issue the order, and it means that the changes were registered successfully. So if you, once you finalize the post-registration procedure, you do not get any written certificate. Instead, you get email notification that, the changes were reflected in public register accordingly. So what can delay the process? Of course, you need to, as I said, complete forms and incorporate all comments on time. Also check any outstanding debt. If, for example, the proposed shareholders that you're planning to add to your register has EIN and also has debt, fines or outstanding tax, the Minister of Justice may refuse to register the details until you make the relevant payment. So, and if you are just a registered participant without having any license, you may just apply documents straight to Office of the Registrar, skipping the step where you need to notify supervision. Here, I'm going to discuss about annual reporting. This part is seems to be controversial to some of our participants, and I will just explain what kind of reporting you need to submit, so you get a grasp of what you need to submit besides of tax declaration. So basically, all participants need to make tax declarations, may submit it online or offline. It doesn't matter. When it comes to licensed participants, again, they need to submit reporting to Supervision Division and to Office of the Registrar. When you submit forms to supervision, it depends on type of activity, type of license that you hold. For example, if you are a brokerage firm, then you need to apply to capital markets. If you are having like CIS license, advising on deals and so on, you need to contact Financial Conduct Division. Here I put the terminology, the designated non-financial business and profession. Here's an exception. So there is only one type of company that perform non-regulated business, but they still need to submit report to Supervision Division. So basically, if you are, for example, engaged in construction, which is non-regulated business in AIFC, but it's associated with high risks, and that's why you have an AML officer, and therefore you need to submit AML report accordingly. So moving further to Office of the Registrar, here you submit reporting based on your organizational legal form. So annual accounts are submitted by the partnerships, non-profit corporate organizations, foundation, public companies, private companies. Annual accounts is all about the financial statements which are reported by an auditor. While annual return, it's all about reconfirming that details indicated in public register are the same, remained unchanged throughout the year, and plus you submit financial statements which are not required to be audited. Annual confirmation statement, that kind of reporting, only private companies may submit it. So what's the difference? For example, if you see the annual accounts foundation must submit annual accounts and annual return together. If you see the organizational legal form under each kind of reporting, it means that you need to submit it. You cannot substitute both of them. And here's private company. How to distinguish what kind of reporting you need to submit as a private company. If, for example, your turnover is more than $5 million and on average more than 20 shareholders, it means that you need to submit annual accounts and annual return. So your financial statements, that includes statement of cash flow, income statement, balance sheet, should be reported by an auditor. So annual return, you may submit only annual return as a private company if your turnover is between $500,000 and $5 million, or on average you have more than 20 shareholders. Annual confirmation statement you may submit if you have turnover less than $500,000 and you're submitting the reporting within the deadline. Annual confirmation statement must be submitted within 2 weeks after the end of review period. Please do not confuse review period and financial year end. And it seems to be the same thing, but a review period is 12 months from incorporation stage, while financial year end can also be like 12 years the registration date, but some companies may change it, and they may change their financial year end. For example, if it's calendar year and ends on 31st December, it doesn't mean that you may submit annual confirmation statement within 2 weeks after the financial year end. So further, here as a market response, we introduced a project, Find an Auxiliary Service Provider, which is published on e-residence portal. Some companies who have some troubles, issues in completing the forms or perceiving the AIFC laws and regulations may seek for professional consulting services. And here you may filter by type of activity, whether you need some support in relation to AIFC services or due diligence consulting and legal consulting in AIFC jurisdiction or foreign jurisdictions. So this was the end of my presentation. Again, thank you for joining our session. And please don't take chances with compliance.
Большое спасибо. Большое спасибо, Assem, за очень содержательную презентацию.
Thank you very much. Thank you very much, Assem, for very detailed information. It's very important to know what happens with the participants after they have registered in AFC, because there are many issues our companies face with. Like you have mentioned, we have a platform for our companies that render professional consulting services. We have the representative of such company. His name is Azat Otepbay. He is a founder of Audit company, it's a consulting company. Azat, I give the floor to you. I'm very happy that you are with us today. Thank you very much for giving the floor. Indeed, the company that registered in AFC has many questions regarding registration, post-registration, and further operation activity, and our company helps them. We help them to register to get the licenses in post-registration. We help them in accounting work, and I would like to speak more about shares in common law, and especially in AFC, and to share with our case how it happens. Could you please show the first slide? Actually, the privileges of shares on the territory of Kazakhstan were provided for joint stock companies, and usually those companies that launched LLPs, where the structure is shown by different shares. What are the advantages of different types of shares that can be issued by different companies? They are not available for everyone, but currently company can register, for example, a private company, LTD, and thus it can have the opportunity to issue different types of shares. So the standard types of shares, ordinary shares, and then the company can update or change the type of shares. For example, we have deferred ordinary shares.
There can be non-voting shares. There can be shares that are redeemable. There are also preferred shares, which are probably most known among other types. There are some cumulative shares where the dividends are accumulated and then paid out. And plus there are the treasury shares when the company can buy back its own shares. Next slide, please. So why do we need those different types of shares? Well, first of all, this is done to attract investment. When the founders don't want to see their share in business diluted, or when the investors do not participate closely in the operational activities, they could issue a certain type of shares for those investors. Or there can be an option when you need to direct a certain dividends into certain types of shares. As it was mentioned before, there is also an opportunity to reduce some voting rights and have non-voting shares. You could also issue shares to motivate your employees when their salaries will be directly linked to the dividends. Or you could specify a condition that when the employee is fired, the shares are returned to the company. In here, I would like to talk to you about a real case that was implemented for AIFC participant. This company was initially registered in the simplest way possible, just to make it speedy. They had 100 shares. They have divided them 40 to 60, one share each. So the charter capital was 100 shares. And the next stage was to raise the capital or the equity. And here we helped in valuation of assets, and by assessing intangible assets, we increased the equity, and as a result, there were 100,000 shares, $2 each. So the first step was to increase the equity of the company and to change the type, or to change the properties and the par value of one share. And by doing so, it made it possible to attract investors and to issue new types of shares for them. Next slide. In this case, our next step was to issue different class of shares. We called it class B. So this is usually called an alphabet shares when company can issue class A, B, C, and so on. Usually, in practice, there are only 2 or 3 types of shares in this class, because in some cases, this can cause some inconveniences in calculating the dividends and so on. But there are advantages here. You can see it on the slide. So we issued additional shares, 20,000 shares, $30 each, and the investor then contributes $600,000. As a result, the investor gets 16% of the company. The equity increases to 800,000. And the founders, in this way, will feel more comfortable in decision-making. The investor, in this case, wanted to put all the money into charter capital. And the advantage here for AIFC participants and also for LLPs in Kazakhstan is that, well, in LLP, you cannot contribute the money directly to the company right away. So you don't do this cash in. And what do things usually look like? They usually buy like a 0.1% of the company, and then they increase the charter capital. But in this case, you can get the money directly into the company by issuing a new class of shares, which is an advantage as well. So these are the types of aspects that you can do. You could change the par value. You could change the number of votes per share. You can identify the rights to get dividends, and by doing so, you can control who among the shareholders has the right of ownership, the right of management, who will be the first in line in case of liquidation. So that's all I had. Thank you very much. Thanks a lot. Thank you, Azat. Thank you for this presentation. Now, in terms of post-registration process and what happens to our participants, we are clear on that. I guess we'll also have a Q&A session later on, and I hope that our audience will have some questions, and we will be able to discuss those. Next, the second block. This is also a part that we wanted to cover today. This will be dedicated to human resources, personnel selection. We have our colleague here with us representing the Bureau for Continuous Professional Development, BCPD. Her name is Dilda. Dilda, please, the floor is yours. Dilda Ismailova, representative of BCPD. Welcome. Thank you very much, Aslan, for giving me the floor. Let me share my screen. Please let me know if you can see the screen. Yes. Thank you. Distinguished participants, representatives of AIFC, fellow speakers, it is my pleasure to welcome you to this forum organized by AIFC Business Connect team. My name is Dilda Ismailova, and I'm head of a project in a chief direction of the BCPD. Allow me to start my presentation by introducing the Bureau for Continuing Professional Development and its main activities. BCPD is specializing in preparing for best international professional certifications by using the best practices in the area of continuous professional development. This is all done to increase human capacity and organize a pool of professionals, and from local specialists to work in the AIFC and also on the open market. Since the time of its creation, BCPD went through different stages, from corporate university, operator of international certifications, center for professional development, to become a financially sustainable system. The BCPD strategy was revised for its subsequent implementation. The new strategy is based on platform, and it consists of 5 dimensions: learn, develop, quant, academy of law, and achieve. And now let me talk about each of these directions in greater detail. The first direction is learn. This is Al-Farabi's platform. The main objectives of Al-Farabi's platforms are to provide career orientation for a younger generation, building required knowledge to ensure success in the modern world. The content of Al-Farabi's is dedicated to diagnosing natural abilities and interests, interviews with professionals, soft skills development courses, communication courses, critical thinking courses, and also courses provided by the local and international partners. Al-Farabi's is a guide for students into the professional world. The second direction is develop. The project there is University of the Future. This is a platform. And the University of the Future is a digital platform for professional development. In 4 years, the University of the Future has provided professional development and retraining to over 5,000 specialists in various directions. Strategic partners of the University of the Future are globally recognized certification institutes in the area of financial management, asset management, risk management, project management. accounting and audit, Islamic finance, and green finance. University of the Future is based on four main approaches, which is lifelong learning, continuous professional improvement, individual learning trajectories, and confirming the knowledge by obtaining international certificates. University of the Future is a center of excellence for development of corporate training. The platform of University of Future can be used by any company to create their own corporate online university by developing individual development trajectories and tracking their progress. The accumulated expertise and a network of trusted partners enables us to develop effective training programs for managers and employees. The next direction is Academy of Law. This is also a platform for legal training. It provides trainings on AIFC law and international commercial practices. Thanks to cooperation with international institutes, the Academy of Law can train students, lawyers, and professionals in business, and also judges. They prepare them for work in AIFC and other financial centers. The Academy also organizes legal events to attract attention of the general public and build awareness about the main values of legal profession. The Academy also provides legal aid free of charge in the pro bono office, and it publishes legal articles on our online channel. And to attract talents, it organizes internships for students from the leading universities. The next direction is Quant. Quant is an online high-tech school based on principles of active learning, project management, and gamification. Since 2020, over 1,500 students have been training in Quant from different regions of Kazakhstan and the world, and Quant is already training specialists in 4 out of top 10 professions in the industry according to World Economic Forum. These are the software engineers, big data analysts, web developers, specialists of cloud computing, and in Quant, both professionals and young programmers can be trained. Quant program is already integrated into some curricula of the universities. Over 78% of the learners are already employed. And the last direction is A-Pro. This is Achieve direction, A-Pro project. A-Pro is specializing in personnel selection thanks to outstaffing, outsourcing, recruitment, and career counseling services. Our goal is to provide professional services in the AIFC ecosystem and to the external market, and also job creation by employing the specialists from our staff reserve, which have the necessary competences and can satisfy the needs of the labor market in Kazakhstan. After registration, the participating companies often see the intricacies of AIFC jurisdiction, and the main challenges in labor relations that the companies face are usually related to regulations. And BCPD and our team in A-Pro has expertise in formalizing this labor relations and process according to AFC law. What can we offer to the participants? Our corporate services are, first of all, recruitment, personnel selection for any type of position. To search for candidates, we look at the staff reserve of AIFC. Right now, we have over 13,000 candidates in this reserve. We also have many years of experience and qualified staff, and we can offer a guaranteed replacement of a candidate within 90 days. And we use an expanded technology for personnel selection and search, and compliance with business ethics is a mandatory condition when working with the clients and candidates. Outstaffing is getting the personnel outside of your company, and during outstaffing, labor contracts for the personnel are signed not with the company that they work for, but rather with an intermediary organization or outstaffing company. The main goal there is to optimize the staffing plan and the budget of the company, and also to reduce the risks related to labor disputes. When should the company start thinking about transition to outstaffing? If you experience a shortage of specialists, but you don't want to increase your staffing structure, or if you have a goal of attracting foreign specialists or specialists from a different region without opening a branch office, or when you don't want to put your employees that are still on probation on your staffing plan, or when you need to reduce your payroll, taxes, and so on. And also to eliminate risks related to financial and tax liabilities for your personnel. We provide a full spectrum of HR administration. We pay out salaries, we provide the necessary tax reports to the government bodies, we provide a healthcare insurance, a voluntary healthcare insurance of employees, we do the military registration, we process visas for employees and their families. Next, outsourcing. Outsourcing for a company is a way to ensure savings on labor resources and optimize accounting. To put it in simple terms, outsourcing is giving a part of the responsibilities of the company to another firm which is specialized in service provision, namely to us. So the company will outsource some services to us and will expect certain results. The work of the personnel of the company is transparent for the client, and we are focused on achieving the result. Outsourcing for a company is primarily about saving the money, because when you transfer some of the costs to outsourced company, this will reduce the operational costs. This is also an opportunity to develop business and save time by focusing on the core activities in the company and by using human and financial resources rationally. Outsourcing is also about reducing operational risks. By outsourcing part of the functions as a client, you only have to control the subcontractor to make sure that they comply with the conditions. And this is also about access to highly qualified personnel and improving the quality of tasks performed. Outsourcing will also reduce the load of the management. The less types of objectives there are inside the company, the more the company can focus on developing their main strategies. In the framework of outsourcing, we provide HR administration, a full cycle administration, according to employment regulations and internal rules of the company, if any. We can develop the organizational structure, job descriptions for administrative staff, develop the HR administration templates, orders, certificates, reporting templates, and so on. Also, we provide accounting support, namely paying salaries, advances, providing tax reports and other reports, and also outsourcing of IT specialists. One more thing that we provide, one more service that we provide in April is the career counseling, and this is a process which helps the candidates in resolving the questions related to career development. Career development includes the choice, mastering, adaptation, and advancing in the profession. We provide career consulting services in two directions. These are the group sessions for corporate sector and also individual sessions for students, specialists of various levels.
And the counseling includes testing, assessment, of professional orientation, identification of the strategy of career development, individual planning and development of career, and also professional profile development. And our uniqueness is that we have the pool of qualified candidates that are in the AFC pool. And over 3 years, this pool received the students that were trained by professional programs, the trainers of the programs, event visitors, people who showed interest and sent their CVs individually, thereby getting in the candidates list. So the main constituency of our candidates, they are professionals with the necessary skills and competencies suitable to fulfill the labor market requirements. What are the requirements for candidates? First of all, it's high education in accounting and auditing, investment management, risk management, human resources management, ICT management, and so on. Fluent English language and related work experience. As I have mentioned before, our reserve pool has 13,000 candidates and its number increasing every day. Our team consists of 4 people. They are Aygerim Dusimbayeva, project manager, Aida Kinjaygarinova, HR supervisor recruitment, Aygerim Samarhanova, HR supervisor that deals with outsourcing and outstaffing. In case of different issues with the services and the BCPD, you can contact with us. Thus, my presentation is over. Thank you very much for your attention. Thank you very much for your time. Okay, thank you very much, Dila. Indeed, human resources, especially in the field and the sector where we work, is very important. Because most part of the companies that are registered here develop their business and structurize their transactions. They are probably big companies, but there are also new companies. And AFC is the jurisdiction where they start their corporate way, business way. And because the most part of the companies render professional services license, financial services, so the services without a good HR capacity, it's not operating. They are professionals. It's not so easy to find such people, and that is why Bureau works very hard and not to help these candidates, to help to find these candidates, but those companies that enter in the center, if they have specific professionals, but they do not have enough competencies and skills, these gaps, together with the Bureau, can be filled in. They can be certified in different fields, and they can strengthen their efforts. We have some questions, and I would like to say that we will have Q&A session, and of course we will discuss in the end of our session, we will discuss how to contact with our speakers, because I can see that you are very interested. Just a second. So we have discussed different outsourcing, outstaffing services, and so on. And another very important topic And question that our participants have, how the labor legislation operates, what is employment regulation in AFC? I think that our colleague that represents the administration of AFC, HR, the head of HR department, Ms. Asel, will clarify all these questions. Thank you very much. I have a presentation. I hope that you can hear me well.
Hi everyone, and thank you for joining our session. Next 20 minutes we will talk about AIFC employment regulation. My name is Asel. I'm a senior manager of HR administration division of AIFC authority. Today, during our online session, I plan to present AIFC employment regulation. So, yes, as it was said, if you have any questions, you may address it at the end of the whole session. On the slide, you may see our agenda for today and the main parts that we plan to go through. Unfortunately, I cannot go deeply, but try to explain today as much as it's possible. So we will start from the purposes and application of AIFC employment regulation. The next topic is hiring process, what is important to ensure during hiring of new employee. Also, we will discuss the kinds of protection of wages that we have. The fourth topic is the working time and leave types. Another important topic are obligation of employees and employers, and two last part related will be related to non-discrimination and termination of employment. So let's start with purposes and application of employment regulation. The main purpose of the regulation is to provide minimum employment standards for employees and employers of AIFC bodies organization, and AIFC participants. So next aim is to provide the applicable law for the contract of employment, and the last one is to foster employment practices that contribute to the prosperity of the AIFC. Important part of the employment regulation is hiring process. So to ensure that hiring process goes right with employment regulation, please remember that requirements of employment regulation are minimum requirements, and the provision in agreement to waive or exclude any of those requirements is void unless expressly permitted under this regulation. An employee may only be employed under the contract of employment that is written in English and signed by both employer and employee. Such contract shall be signed within 2 months after the start of employment. If the employee does not have sufficient competency in the written English language to understand the terms of the contract of employment, the employer must ensure that terms of the contract are adequately explained to the employee. But in any those situation, English language has precedence over any other language used in the records. So the contract of employment must include the following as minimum. Of course, it's the names of the employer and the employee, the date of the start of the employment, the employee's wages, the applicable pay periods, any terms and conditions relating to hours or days of work, any terms and conditions relating to vacation leave, pay for vacation leave, national holidays, and pay for national holidays. And you need to include any terms and conditions relating to sick leave and sick pay. Another minimum requirement that must be included in contract of employment is the length of notice that the employee and the employer is obliged to give and is entitled to receive to terminate the employment. The titles of the employee's job or a brief description of the employee's work, in another words, is job description. And if the employment is not intended to be for indefinite duration, you need to indicate the period for which it is expected to continue, or if it's not for fixed term, the date it is to end. So please indicate the place of work, any disciplinary rules or grievance procedures applying to the employee, and if it's applicable, anything else prescribed by rules made by the board. So employer must ensure that the contract of employment expressly states the matters relating to the employment of the employees that are to be subject to the employer's policies that may be changed at the employer's discretion from time to time by way of written notice to the employee. An employer may require an employee to undergo a probationary period, but if the probationary period does not exceed 3 months and is specified in the employee's contract of employment. During the probationary period, either the employer or the employee may terminate the contract of employment without cause on 1 week notice and for cause without notice. An employer must keep a copy of each employee's contract of employment and any records on employee's employment. Such records must be in English and kept by the employer for a minimum of 2 years after the employee's employment terminates. Such information may be kept in electronic format, but you may kept it in hard copies too. Let's go to protection of wages. An employer must pay an employee the employee's basic pay within 5 business days after the end of the pay period. Pay for vacation leave must be paid no later than 5 business days before the day the vacation leave starts. In case of termination payments must be proceeded within 14 days after the date of termination. By the way, employees has protection on authorized deduction of payments unless such deduction are under legislation that applies in the AIFC or contract of employment. Another reason for deduction is if such deduction were preliminary agreed with the employee, or such deduction are reimbursement for an overpayment of wages. In any other cases are ordered by the Astana International Financial Center Court. Working time and leave. What I can say is that employees' working time must not exceed an average of 40 hours for each working week period unless the employer has obtained the employee freely given informed prior written consent. And employees' working time on a day must not exceed 8 hours unless the employer has obtained the employee freely given informed prior written consent. An employee is entitled to paid vacation leave for a minimum period of 20 business days per year, or an employee is entitled to carry forward accrued but untaken vacation leave up to a maximum of 5 business days into the next year for a maximum period of 12 months. Any unused leave expires at the end of 12 months. An employee is entitled to sick leave not exceeding a maximum of 60 days in total in any 12-month period. If an employee takes more than aggregate of 60 days of the sick leave in any 12-month period, the employer may terminate the employment immediately with written notice to the employee. An employee also entitled to maternity leave for a minimum period of 12 months. During the minimum period, 12 months is the minimum period. During the minimum period of maternity leave of an employee, the employer must pay the employee, first of all, as the employee's normal daily wage for the first 33 business days of the period, and at 50% of the employee's normal daily wage for the next 32 business days of the period. An employee who becomes a father to a newly born child is entitled to paternity leave for a minimum period of 5 business days. If a female employee is caring for a child younger than 18 months old, the employee is entitled to feeding breaks of 30 minutes in every 3 working hours. The employee is entitled to be paid at 100% of the employee's basic pay for the feeding breaks. Important part of the employment regulation, of course, is obligation. Here I mentioned the obligation which are not described before, and an employer, you should remember that employer also has a duty to ensure, as far as reasonably practicable, the health, safety, and welfare at work of all employers' employees. Such duties include health and safety issues, ventilation, temperature in indoor workplaces, lighting, clean lines, room dimensions, and space workstation condition, sanitary conveniences, providing drinking water, health insurance that cover work-related injuries, compensation for employment accident and occupational diseases, and data protection. And 1 minute. And here you see the employee's obligation. So first of all, of course, employee has a duty to perform the employee's employment duties with reasonable diligence and care. Of course, obey the orders of the employer, but in case if the orders are consistent with the employee's employment duty, will not expose the employee to danger, or will not constitute a contravention of any regulation or other acting law of the AIFC or of legislation of Kazakhstan that applies within the Astana International Financial Center. Comply with the health and safety instruction of the employer, to take reasonable care of any of the employer's property, not accept any gift or advantage from any person for performing the employee's employment duties, not compete with the business of the employer, and the last one is not disclose to a third party any confidential information of the employer during and for an indefinite period after the termination of the employee's employment. Our non-discrimination part, so an employer must not discriminate against any employee regarding employment on or any term or condition of employment or any of the following grounds. First of all, it's sex, marital status, race, nationality, religion, age, and disability. And the last, our topic for today is termination process. So termination, according to AIFC employment regulation, may be proceeded with notice or without notice. Minimum notice period you may see on a slide. An employer may terminate an employee's employment without notice for cause. Termination by the employer for cause is termination first because the employee has committed a crime. If the commission of the crime has a material and detrimental impact on the employer. Second, because the employee has committed a repudiatory breach of a provision of the employee's contract of employment. Third, because the employee has materially contravened this regulation and the contravention has had a material and detrimental impact on the employer. And the last one, for another reason prescribed by rules made by the board or by the employee's contract of employment. For today, it is everything. It's all. So here you may see our contacts and our team members. If you have any questions, you may address to our email address or contact with BC. So thank you, Aslan.
Да. Спасибо большое. Спасибо, Асель, за...
Thank you very much. Thank you very much, Asel, for very detailed information presentation. Indeed, I learned a lot from your presentation regarding those issues that were open regarding employment regulation. In the very beginning, I have said that we have representatives of participants companies, consulting company, that is the participant of our company, the company with a huge expertise and a good team. We have the representative of this company, CEO, his money laundering officer, Ainur. I'm very glad to give the floor to you.
Thank you very much. First of all, I want to congratulate all of us with this amazing event. And today I'm talking after Asel about how lean as possible set of rules can spread out the opportunities to do your best at AFC. So the main topic is AFC employment regulations versus Kazakh labor code. As you already mentioned, we have previous years, right? The questions to set a company, how to become a participant, and so on. It's like naturally, you give a birth to the child, and child is growing. So the same thing happens to AFC, and AFC is growing, and which is really good. And now we are facing these, let's say, issues, or challenges, how to regulate the relationship, especially employment relationship in AIFC, because AIFC it is another jurisdiction from Kazakhstan, from Kazakh legal jurisdiction. So that's why what it shows that we are today have grown that big that we are facing these challenges. So this is good. Let me move. Regarding the, can I have next slide? Thank you. So around 800 companies are currently registered in AIFC. Due to its location on the territory of Kazakhstan, it is obvious that AIFC employees are mostly citizens of the Republic of Kazakhstan. And we face the questions, how my employment relationships regulated in AIFC if I am Kazakh resident. Also, please next slide. Well, this legislation of AIFC is based and consists of the constitutional law, which is the main law of, on the International Financial Center, Astana, acts of AIFC based on the principles, norms, and the precedents of England and Wales and other standards of the world's leading financial centers, applicable legislation of the Republic of Kazakhstan, which applies to the extent not regulated by constitutional law and by the acts of AIFC. This, the last my point is a very important part of my topic, because we will be going to compare employment regulations of AIFC with labor code of Kazakhstan. So therefore, what I want to point out that applicable legislation of the Republic of Kazakhstan, which applies to the extent not regulated by the constitutional law and by the acts of AIFC. What does it mean? It means that this amazing employment regulations of AIFC has no waiver, and at the same time, waiver of the minimum requirements established by the regulations is not allowed, and any terms of the employment contract on their inclusions are invalid. So what does it not regulate? It is meant to be regulated by labor code. But at the same time, they have differences in regulations. So let's get into it. Can I have next slide? So International Financial Center, Astana International Financial Center, has introduced the employment regulations governing labor relations between employees and the employer of AIFC since 1st January 2018. Next. The regulations establish only the minimum requirements to be followed by the employer and the employee. But an employment contract concluded may establish conditions that are more favorable than those established by the regulations. The same approach is used by the Labor Code of Kazakhstan. Next slide, please. So, as I said, already explained the main regulations and main requirements of the regulations itself of the AIFC. Let me put some comparative. You cannot conclude, you cannot enter into employment contract. Can I have the slide before? Oh yeah, thanks. Employment contract with the person under 18 years old, while in Kazakhstan you are allowed to do it with the person already reached 16 years old. And next is greatest opportunity for the foreigners is they are exempted from obtaining a work permit in the Republic of Kazakhstan, while Kazakh Labor Code requires to obtain work permit and proper work visa. A signed copy of the employment contract. This is very interesting point. So, as I said already told, and as we know from the regulations, that the employment contract shall be delivered within 2 months, according to AIFC regulations, while in Kazakh regulations, you cannot start your work without signed contract and handing it in your hand. So, following, why this is interesting question? Because already, according to cases happened in AFC in this short period, there were some interesting dispute resolved by the small claims court of the center of AFC on the claim of Nur-Sultan Aliyev against Opportunity Management Company LLP is indicative, despite the fact that the claimant declared in the claim the violation of the procedure for terminating the employment contract. During the process, the question arose whether the parties have entered into the employment relationship due to the absence of the written agreement signed between the parties. After clarifying all the circumstances of the case, the court concluded that the parties did not enter into labor relations, and the claim of Aliyev was rejected. So, what it shows, this is very interesting point. So, there is a contract and it is not signed yet. You have 2 months, but the person is working, and now the question is about termination. But the court found out that before they discussed the termination, they didn't even sign the contract. So, yeah, be careful about that. The employment contract must contain the terms of work, while the Kazakh law requires can be concluded. We can start only after conclusion. The employment contract can be concluded for a certain period, at least 1 year, for an indefinite period of time. If while the AFC regulation allows to sign the contract for indefinite period or set exact period of the contract. Next slide, please. What obligatory provisions of the employment contract? Let's go through this also. So, if the regulation requires the names of the employee and employer, while the labor code calls it details. So, what the name and the details, the difference is when you put the name, you just put your name and maybe some requisites, but it is not really required, while labor code requires to put full details, your individual identification number, addresses, and so on. Next, the date of the start of the employment. There should be a date in the contract of the start of the employment. Work under certain, while Kazakh law requires work under certain specialty profession qualification. So it requires to have a special position, while in AFC contract, it is not really required, not obligatory provision. What next? Employees' wages, applicable pay period, hours or days of work, terms of employment contract, title of the employee's job, place of work, and other provisions as provided by paragraph 4. While this is the same almost, place of work, term of employment contract, working hours, remuneration, rights and obligation, the procedure for changing and terminating employment contract, and other provisions. Please, next slide. Main obligations of the employee under the regulations are perform duties with reasonable diligence and care, to obey the orders of the employee, to comply with the health and safety instructions, to take reasonable care of any of the employer's property, to not accept any gift or advantage from any person for performing the employee's employment duties, to compete with the business of the employer, not to disclose to a third party any confidential information of the employer. Well, main obligation, next slide please. Main obligations of the employee under the labor code are fulfill labor obligations, observe labor discipline, comply with the requirements for labor safety and protection, take good care of the property, not to disclose information, to compensate the employee for the damages, other obligations. So basically, the obligations of the employees are similar and looks alike. What about, next slide, main obligation of the employer? This is very interesting. It is not really what we used to have in Kazakh jurisdiction, let's say. So what the employer must do to ensure health, safety, and welfare of the employee, to provide employees with working conditions. It is ventilation, adequate supply of wholesome drinking water, reasonable temperature, and etc. To acquire and maintain valid medical insurance, to pay compensation for the employee an injury, to protect the personal data, other applications as provided. Next slide, please. What are the main obligations of the employer under the labor code? So, to provide the employees with working conditions, to conduct training, instructing, testing on safety and health issues, to acquire employee insurance, to carry out mandatory periodic medical examinations, to protect the personal data, other obligations as provided by the labor law. What is the interesting about that is that we have another, in Kazakhstan, different rules which may regulate the conditions that employer must provide for the employees, depending on the jobs they are involved and qualifications. I don't know that we have the requirement to provide with the drinking water. This is interesting. Can I have next slide? Mm-hmm. So, types of leaves under the regulations and the labor code. So, AFC regulates following leaves: paid annual leave, leave provided on national holidays, falling on weekends, sick leave, maternity leave, paternity leave. The labor code has paid annual leave, and then the following are just social leave, which includes unpaid leave, study leave, leave in connection with pregnancy and childbirth, adoption or a newborn child, unpaid leave to care for a child until the child reaches the age of 3, leave of screening tests of not more than 3 working days per year, leave for at least 3 working days for pregnancy registration made up to 12 weeks. The regulation can I have next slide? Paid annual leave. So the main differences about the paid annual leaves is AFC requires the employer to guarantee 20 working days of minimum vacation, while Kazakh law 24 calendar days. And it's quite different in days, in terms of days. Vacation leave occurs pro rata for an employee who has been employed for at least 90 days in a year. The law, Kazakh law, does not contain a requirement on the procedure for calculating leave depending on the period worked. What does it mean? It means if the employment is on AFC ongoing more than less than a year, so the employer can count the vacation pro rata to the time period he already worked. While Kazakh law does not put such requirement, but in practice, employers do count this because this is their risk. Next, any unused leave expires at the end of the 12 months. So what is it? Employer can send the employee, if he didn't take his vacation, to the vacation by giving a notice beforehand, like 15 working days. So once he sent the notice 15 working days before, the employee has to take this vacation and go for vacation. Employer may require any employee to take vacation leave on specific day. So, or they can agree on that. In Kazakh law, the sequence of providing paid annual leave to employees is determined by annual schedule, or they agreed with the employer. Next slide. Maternity leave under the regulations. Maternity leave is different and interesting. So we have 12 months of maternity leave in AFC, while Labor Code provides 70 calendar days before the birth and 56 calendar days after birth. And if there are some circumstances like difficulties with the health of the woman or the child, it is given 70 calendar days after the birth. And about the payment, it is interesting that employer at AFC has to pay like 33 working days of the maternity period, like a full age daily, and after the birth, 50% for 32 working days of the wage. While in Kazakh regulation, it is paid by social insurance. So social insurance, state social insurance fund pays, and to make it paid, you have to make sure that your employer is supposed to be paid social taxes under your name. Then you receive your maternity leave payments from the state body. This is the difference. Next, paternity leave. Well, Kazakh regulation doesn't have such a leave, but if you became a father and you have this amazing event in your life, you can take up to 5 days unpaid leave, while at AFC, paternity leave can be given at least 5 working days, and it will be covered by the employer. This is what I call spread opportunities. Well, next, sick leave. Sick leave. Well, sick leave is, like I said, told, it is like 60, it is already included, so it is 60 days within 12 months. And you can just notify, and if you are exceeding for 60 days, or you just can notify your employer, and if you are exceeding, you just have to, by his request or her request, send and show the medical opinion that you're still on the sick. If you are leaving for 1 day for sick leave, and you still shall be paid for this day if you properly notified and had the consent of the employer. While labor code doesn't have, employee is exempted from performing the labor function if he is ill and have a proper certificate of the temporary incapacity to work. And the employee has the right to terminate the employment contract on its own initiative if the employee is absent from work for more than 2 months in a row due to temporary disability, except for cases as provided by the law. So if there is a leave, sick leave for more than 60 days, and they don't fall under the requirements under the law or exempt, the employee can terminate it. While AFC employee can terminate the employment contract by sending a written notice. So we are moving to termination. Therefore, what is the termination? It is everything. I have a comparison, like when you have something you entered in, and if you look at this like life, everyone come to life and go. Unfortunately, all of us will go someday, but it's the same thing with the legal relationship, especially like when you enter into a contract. There is a beginning and there is should be ending, right? So ending, in our case, it's termination. How we terminate? Regulations at the AFC not really specified in this purpose. An employment contract between an employee and an employer can be terminated at any time by either party without any reason, by sending a notice to the other party. While in Labor Code, Kazakh regulation, Article 49 of the Labor Code contains exhaustive list of grounds for terminating employment contract. So, according to Kazakh law, you cannot terminate the contract just like you want. Of course, one of the reasons it can be when the parties agreed, not the parties noticed each other, but agreed or maybe noticed each other in advance following the contract itself. Can I have next slide? So the employer can terminate the employment contract without notifying the employee based on the following reasons. The employee has committed a crime. The employee has committed a repudiatory breach of the provision of the employee contract. The employee has materially contravened these regulations and had a material and detrimental impact on the employee. While the labor code, the employee can dismiss the employee only on the grounds provided for the Article 52 of the Labor Code, which contains more than 20 grounds for dismissal of the employee on the employer's initiative. Definition, unfortunately, the definition of material and detrimental impact, which allows to terminate for the employer the employment contract, like committed crime, committed a reputable breach, materially contravened, are not specified, and it leaves a gap or opportunity for the employer to use the situation for his benefit. Therefore, we have analyzed the labor code and regulations. And going back to the first statement, what I wanted to emphasize is that what is not regulated by constitutional law and regulations of AFC, it is regulated by Kazakh law. So in conclusion, we understand that if something not regulated in regulations of the AFC, employment regulations, then it probably will be regulated similar like in Labor Code of Kazakhstan. But at the same time, we have to keep in mind always that there is no waiver and we have to follow the regulations to the fullest. And what exceeds, we go to Labor Code. So, and my last slide is in order to avoid the occurrence of disputes on issues not regulated by the regulations, the employer is recommended to develop a detailed employment contract that would fully cover all issues arising from the employee's work in the AFC. So Muratov Law Firm Limited can do it for you. Well, that's it.
Огромное спасибо, Ainur.
Thank you very much, Ainur. I think that as for most of the questions that we have received during the session regarding employment regulation, but after some time, they say that all these questions were answered. Of course, we have some questions and we address these questions to you, address to you, Asel, but dear participants of our session, dear guests, now we will transfer to the session of questions and answers, and I divided them into blocks. The first, we have two interesting questions. I would like address Assem regarding post-registration, and the questions are the following. Can the participants of AFC work outside the jurisdiction's border if the company, for example, is registered in specific jurisdiction, but probably its clients or some partners are outside of the jurisdiction, for example, in Almaty, how to have these relations? And the second question is similar based on the context. Can the participants of AFC found some organizations, LPs, for example, are based on Kazakhstani legal field. So can a company AFC, can it be a founder, for example, LP in Kazakhstan? Assem, please, the floor is yours. 2 questions to you that are very interesting for our participants. Wonderful questions. Having responded to the first question, participants can work outside AFC or Kazakhstan if this jurisdiction doesn't prohibit this specific type of activity or the company got a license. If we show an example, let's take, for example, a company that registered its head office in AFC, but it fulfills the activities on the production of medicines, and this activity is allowed, but it's not regulated. But in Kazakhstan, they have to receive the license, and in this case, the company can be regulated by the corporate law, by the register of the company, and the activity will be regulated by specific laws of the Republic of Kazakhstan. And the second question is connected with, yes, if AFC company can become a shareholder of LP, yes, it's allowed. There are not any limitations. Our legal act doesn't prohibit it, and the company may not notify AFC about it. They just directly approach to the population services centers and register LP. I hope that I answered your questions. Yes. Yes, Assem, thank you very much. You answered these questions. I think we need to note there are some categories of the participants because of this issue are registered in our center. They are representatives of big enterprises. They register holding structures in AFC in order to gather all the assets in our jurisdiction. And indeed, it probably shouldn't be in Kazakhstan. We have some companies that are registered in AFC, but their assets actually can be anywhere in the neighboring countries or in another continent. Practically, actually, it's valid. And the next questions we have to the representatives of our consulting companies, specifically to Azat Otepbay. Actually, we have several of them, but I think we may combine them. Some of them are similar. Azat, can you hear us? I will address all these questions to you. And here the participants are interested in the following. Can a consulting company or audit company represent the interests of our participants from the moment of registration till the moment of interactions, for example, with Ministry of Justice? How actually it happens and how consulting companies interact with clients, in this case the participants of AFC or potential AFC participant, and what are the additional services that can be rendered in framework of our jurisdiction. Thank you very much for your question. Yes, we have some clients who work outside Kazakhstan. We have some clients, one from Japan, one from Singapore, for example, for whom we prepared all the documents in order that when they come, everything would be ready. The only moment For example, when they register via digital residence, all the procedures are conducted online. When they apply the documents, they also can give us all the responsibilities and rights to represent their rights, and our license gives us the right to interact with different bodies and to represent the specific companies. And also we can represent their interests in tax bodies via letter of attorney. It's done in order for the client to come only once, for example, to open the bank account. They receive the key to prove the payments, for example, and usually for our accountants, we take the electronic keys in order to register the payments, and all other issues, everything that is connected with their activities can be provided via letter of attorney. Thank you very much, Azat. Azat, indeed, we have another question that we want to address to you, and one of the viewers is interested. Could you please tell us in details about the processes of the Danish company of TAP? For example, when they register, for example, it's private company Ltd, and they turn to SPC, special vehicle company, for example. What they should focus on, how to organize this process? How can you help our participants with it? As for acts, AFC acts help to change the type of ownership from private companies, for example, but the simplest, when some types of companies are changed, it's easier when we transition from public to a private, from special purpose company and so on. But when there are some transitions from partnerships too, the company, there are some difficulties because I cannot answer this question right now, because we need to look at these cases in details and carefully. Thank you. Thank you very much. Okay. There is a question from Murat of Law Firm for Ainur. Indeed, your presentation was very detailed. Thank you very much for your work when you compare two jurisdictions, labor code and employment regulation. I also found different things for myself. Thank you very much that you disclosed this information. Probably I could also use maternity leave. Thank you very much. The question is the following. Could you tell me, please, to what extent for our participants it's necessary to register labor agreements that are concluded with the participants of AFC in unified register, in unified system of accounting of labor agreements? Is it necessary? Actually, I'm very pleased. Aslan, thank you very much for your question. As for such a requirement, there is no such a rule in AFC, but because, for example, there are some employees or residents of Kazakhstan, the registration of labor agreements is not so probably urgent, but it's more for you because you pay taxes. And if, for example, your foreign employees that you have the agreements with are free from individual corporate tax, on the one hand, AFC rules are not mandatory, but for your activity and for your business, in order to avoid any problems, I would recommend to register. Thank you very much. Okay, I have a question to the representative of administration HR, Ms. Asel. Asel, can you tell me, please? By the way, I think the same question could be addressed to you, like to Ainur. Can you comment it, please? And the second question, we have some participants who do not directly hire employees, but their interaction, for example, with the employees of the company, made via special contracts on services delivery. For example, they can be freelancers, experts.
So how will this format of communication with the employees be built in AIFC? Are there precedents? Are there any interesting cases related to that scenario, or anything that you would like to elaborate on, please? Speaking about registration of labor contracts, I should mention that right now there is no such requirement, and usually, given that the official language is English, in this case, Azat does not allow us to even put the contracts into the system there. In relation to the second question, as far as I understand, you mean the civil contracts, then they are not part of this employment regulation. In the employment regulation, we speak primarily of the employment contracts. All right, thank you. Thank you very much. And a question to Dilda. In relation to the Bureau, there are some interesting things that the Bureau provides to our jurisdiction. Dilda, I have the following question. Do you plan any events? Because right now we have already probably reached a critical mass. We have a significant number of companies, and all of these companies are attractive employers for our domestic market. Do you plan any activities in the job fair format? We understand that probably in the current situation, it's quite difficult to do it offline. But do you plan to organize some kind of online activities maybe in this area? Are there any companies that come up to you with these initiatives, asking these questions? So are there any companies that would like to maybe not only participate, but act as partners, or maybe hold these kinds of events themselves? Anyone ready for cooperation? Could you elaborate about plans? All right, thank you for the question, Aslan. So let me start with the following. As I have mentioned before, we have several different directions, and each direction is launching their platforms or projects independently of the other, and there are many activities that are going on right now or are scheduled for the summer or the fall. So if you're interested about any other directions of our work, this information will be available through their platforms. There are schedules, types of events, so you could learn it there. In terms of APRO, we do have an idea of having a fair. We were initially planning it for the summer, but because work is underway on creation of APRO platform, we might do this type of fair a bit later in the year, a fair for employers and candidates. But most probably this will be done in online format, because the situation right now does not allow to do that offline. Okay, got it. Thank you. I see one more question here. There was a great initiative, and I guess it will be continued. This was the internship program BSTAR that was organized by the Bureau. There are members who are asking us questions. They want to launch their traineeship or internship program themselves. And those types of initiatives have a good impact on brand development for the employer, It allows for better interaction with the students, with the universities. How did the Bureau build this work in terms of communication? Do you plan to continue this Restart program? Do you plan any events together with the participants? Thank you for a great question. We have a lot of partners from the universities who could participate in these types of activities. Right now, our directions are launching their own internships or traineeships, like Al-Farabi might have their digital internships for students. Quant is launching its internships, digital internships for IT. So the activities of the Bureau right now are more or less independent for each of the directions. But as a pro, we can do that if there are many companies who want to organize a joint program. We could probably do that. We could organize it. This sounds like a great idea. We are open to it. But so far, we have not planned a program like Be a Star. We might do something new, something interesting, but not exactly Be a Star. That's a pity because that was a great program. All right, so we still have some questions left, and I'll probably cover them myself. These are the favorite questions that are most often asked of me during my activities. Often people ask how they can become a participant of AIFC. So, distinguished audience, in all our open information sources on AIFC website, on Business Connect website, we have links to e-residence. This is the platform for online registration. On the same platform, you may find the contact details of our employees, so you can either call them or send them an email, and our specialist will talk to you, will tell you about the registration process, will give you the necessary links and materials. And we also have 2 representatives of the consulting companies that will help you with pleasure as well. So that's in relation to becoming a participant. And there was another question related to the timeline for obtaining an BIN. So we should probably look at it on a case-by-case basis. I suggest to do the following. Each of the participants in the process of registration will always have a representative of our team, and you can talk to your account manager and we'll look into it. If there are any challenges in obtaining a BIN, we need to look into it because there are several parties involved. There are participants. Sometimes there are also the companies that assist them, the consulting company, regulators, and so on. So, Department of Justice, we try to streamline it all and simplify it. It's mostly digital, but certainly there are some cases. So it is very important to understand that each company is a unique project, and it rarely happens that everyone is following the same scenario in becoming a participant because there are different structures internally. So we need to look at it on a case-by-case basis. So we have covered the questions. And I think that in the end, it's very important to mention that all the contact details of our speakers, all the ways to contact them can be provided to you. So you can contact us and I will introduce you to our speakers and colleagues with pleasure. I also would like to thank our speakers for having found time to participate in this session, to share this important information. And AIFC is already a well-designed market. We all have almost 900 participants. And as I've mentioned, those 900 participants, have their own path, their own interesting cases and projects internally. I think that if in the past we were going through the early development stage, now we are coming to the next stage in our development, and each of the participants already understands what AIFC means, what's their purpose, and they start already looking for business opportunities. Some of them are looking for partners, others are looking for investors, clients. So they already start working on some operational matters of proper hiring, looking for talents, regulating. So I thank everyone for participation. And once again, it was my pleasure to see you all, and I wish you all the best. Thank you very much.